Ori, the question is, this bill be read a second time.
Mr Speaker.
I'll call the member for Coogee.
Thank you, Mr Speaker. I rise to speak in support of the Drug Court Legislation Amendment Bill 2014. The purpose of the bill is to make a number of changes relating to drug treatment for convicted criminals and clarify issues surrounding eligibility, access and functionality of the Compulsory Drug Treatment Correctional Centre, which is located in Parkleigh. The bill legislates recommendations made by the former Minister for Justice, contained in the May 2013 review of Compulsory Drug Treatment Program Centre pursuant to the Crimes Administration of Sentences Act 1999. To implement those recommendations, the bill amends the Drug Court Act 1998 and Crimes Administration of Sentences Act 1999. The review and culminating legislation reaffirm the value of the original policy and the value of the centre in providing compulsory treatment to people who are addicted to drugs, which has led to their criminal activities and convictions. It clarifies some of the processes and procedures described in the original bill. It aims to increase access to the CDTCC by expanding the legislative provisions surrounding the eligibility and suitability of participants to the centre. The Compulsory Drug Treatment Program was established through the Compulsory Drug Treatment Correctional Centre Act of 2004, which laid the groundwork for proclamation of the facility as a formal correctional centre 2 years later in 2006. It is adjacent to the privately operated Parkleigh Correctional Centre and is the only centre of its kind in Australia, providing a dedicated program for rehabilitation of criminals under the heavy long-term influence of drugs. The centre houses up to 100 recidivist male offenders who have a long history of long-term drug addiction associated with repeated criminal convictions, and those whose incarceration in another facility would not benefit their long-term prospects for rehabilitation. For those who have cultivated long criminal histories associated with drug addiction, incarceration in other facilities can often exacerbate their condition. Often, their criminal histories are directly related to drugs based on actions that they have taken in desperation to secure drugs. If a prisoner is heavily dependent on drugs, then they are unlikely to benefit from their punishment in a standard correctional facility and often emerge from prison ready to reoffend. This is obviously not in anybody's interests. Therefore, the centre offers treatments with the aim of ending the cycle of drug addiction, fuelling or complementing criminal acts. Presently, to be eligible for consideration to participate in the program, an offender must have 1. Been sentenced to a prison term of between 18 months and 3 years, 2. Been convicted of at least 2 other crimes in the preceding 5 years, 3. Not being convicted of the same specific offences, and 4. Resides in metropolitan Sydney, and finally 5. Is over 18 years of age. If these criteria are met, the offender can be referred to the drug court. The drug court then assesses whether the offender has 1. Long-term drug dependence, 2. Whether the facts and antecedents of the offence indicate long-term drug dependence and associated lifestyle, 3. Must not suffer from a serious mental condition that may lead to violence or restrict active participation in the program. Once the criteria are met, the drug court can impose a compulsory drug treatment order. This program has been independently evaluated by the Bureau of Crime Statistics and Research, who concluded that the program has been successful in the effective treatment of offenders with long-term drug dependency and preparing them to reintegrate into society with a lower chance of reoffending. This is good news for the individuals, and most importantly, it is good news for our wider community. I'll address some of the specific amendments in this legislation. Firstly, the eligibility to the program is extended on the basis of the length of the prison term to include offenders sentenced to a prison term of between 18 months and 6 years rather than 3 years. Also, the requirement that an offender must have committed at least 2 prior offences in a 5-year period resulting in imprisonment, good behaviour bond or community service is removed. As per the recommendations, eligible convicted offenders now include a person whose bail has been revoked and who is subsequently referred to the drug court, rather than only offenders who have just been convicted of their crime. Under the legislation, an offender may be referred to the drug court if they have been convicted of a crime involving a firearm, but they are not discounted if they have committed previous offences relating to firearms. This is a change from the current disqualification of anyone previously convicted of an offence related to firearms. A requirement to introduce that the State Parole Authority refer an offender whose parole has been revoked and whose sentence was previously subject to a compulsory drug treatment order to the drug court, with a new provision to determine whether they should be subject to another order. In turn, the legislation also extends the effect of an order to include suspension of an offender's potential eligibility to be considered for parole for the duration of that order. The legislation clarifies that a multidisciplinary team treating an offender must have regard to the offender's history of crime involving weapons and crime involving long-term drug dependency when assessing their suitability to serve a sentence by way of compulsory drug treatment order. The legislation also enables savings and transitional regulations to be made as a result of amendments to the Act. At the Compulsory Drug Treatment Centre, there are 3 treatment stages comprising periods of closed detention leading to semi-open detention and eventually community custody at an approved accommodation. The bill makes provision for the director of the centre to regress an offender from one stage of treatment in the facility to a previous stage where required for a period not exceeding 3 months, and where the offender has failed to demonstrate serious respect in complying with their treatment plan. The director will be required to notify the drug court of such a decision within 7 days of issuing it. Furthermore, the bill provides that a compulsory drug treatment order be terminated when the drug court is of the opinion that an offender's progress in the program is insufficient and that the offender is unlikely to make any progress. In these instances, the court must consider the advice of the director of the centre. Where an offender is sentenced to a term of imprisonment to be served in a standard correctional facility concurrently to a compulsory drug treatment order, the offender must be referred to the drug court to determine whether that order should be varied or revoked. In situations where a drug treatment order has been revoked, the State Parole Authority may consider that the offender for parole less than 60 days before the offender's parole eligibility date. In addition, when a drug treatment order is revoked, the authority may consider an offender's case at any time after the parole eligibility date without a need for an application. In light of the success of the program already, it's clear that long-term drug dependence and associated criminal behaviour can be eliminated or at least contained. The bill enables these functions to continue and at earlier stages than previously provided for in the current eligibility criteria. The legislation therefore remakes it possible for offenders to participate in the program before they have had the chance to offend again, and this could help break the cycle of drug dependency and associated criminal behaviour. I'd like to commend the former Attorney General, who's with us in the House, the member for Epping, and the current Attorney General, the member for Wakehurst, for continuing to strengthen this very important piece of social policy in this state, and I commend the bill to the House.